All right, we are live, ladies and gentlemen, and I will hand the floor over to our fearless leaders of this presentation. Molly, would you like to take over at this point?
Yes, hello, and thank y'all for introducing. I know y'all probably know each other, but it's super helpful for us. We know some folks here really well, but many faces are new. I'm gonna kind of start us off with telling you a little bit about how we arrive at our legislative priorities, and then shift into going into more detail, me, Alex, and Krista, about what those are. We know this is kind of formal, informal, so please feel free to raise your hand, chat in questions at any point. I think we had a chance earlier with folks, and kind of one of the things that came from it were really great questions and really great input. We know you're the experts in your community, so as we're offering stuff, feel free to ask us to pause, or if there are things that are different or particular to your community, please feel free to let us know. Just so you're kind of aware, TCFV usually holds each session a legislative agenda, somewhere between 3 and 5 priorities. We do that because when we pick priorities, we really put our full effort, the entire policy team behind it. And so you got 4 of us here today, but when we're all together and fully staffed, there's 13 of us. We all hold really different expertise areas. So you may have noticed when me and Alex and Krista introduce ourselves, we all have the same title, but we definitely don't know all the same things. And that's one of the benefits of our team, is each of us has expertise in certain areas. So that's why you'll hear from each of us as the expertise pertains to what we do. When we think about our agenda, we say it's TCFV's agenda, but we really hope it's the family violence movement's agenda. And so we get together a committee of around 20 folks, give or take a few people, who spend almost 6 months or more helping us think through ideas. Usually at the start, we have almost 100 ideas, really great ideas, every single one of them, that we all as a committee get to work through. And I know that's something that it has been on many times, Patricia, in the past. Like it's really benefits from the expertise. And it's not only family violence programs, but we have survivors, attorneys, judges, healthcare system experts. Really, when we think about a survivor and their family, all of the people they touch, we want those systems informing our legislative agenda. And so coming together by the end of that 6 months, we really sort through what's really legislative, what might be regulatory, where there's a community that could kind of garner support around a particular issue, and where maybe there is a statute and there's a training issue. So kind of sorting through and then getting to what are those priorities that are really survivor driven, right? So if we're doing something, it should be because a survivor really needs and wants it, and it impacts survivors directly. And that we're really looking at is it something that we can push forward as TCFV, right? Are we best positioned? So the ideas you're going to hear today, really, we call them TCFV, but we really hope it's the movement's ideas, and that TCFV is going to use the strength of our policy team to move them forward. We also want to say, if you're like, but this one idea is not on there, please know there were hundreds of good ideas, all that probably should be done at some point for survivors. So you really are looking at what are those really critical ones to do right now. And so I'm going to talk about our first, and we will say our most important one, and that's appropriations. We consider that our kind of our top bill, our core priority. So for us, when we're talking about appropriations, we have 3 prongs to appropriations. I'm going to talk about each of them. We are talking about family violence program funding. We talk about batterer intervention and prevention programming, right? So BIPs. And we talk about domestic violence high-risk teams, or DVHRT. Those are the 3 areas we put a lot of energy and time into, and make sure that when we're advocating for all 3 of those funding priorities. The first, our topmost priority, is funding for family violence programs. And in a minute, I'll let Marita or Patricia add anything they want, because we know you have 2 of the most amazing in the state, and we're not biased by any measure in your community. So for us, those funds are the funds that go to the Health and Human Service Commission Family Violence Program, HHSC. And we are requesting, coming into this session, $65 million or $63,500,000. That's level funding. That is funding that only keeps lights on. that keeps advocates working in programs, that keeps the door open for survivors. It's an important distinction because we are also asking for an additional $13 million. We know how hard of a budget session this is. You know, much like y'all and those of y'all who are in government relations, we watch the comptroller's estimates. We look at all the financials come in. At the same time, we know in our state 9 years ago, 1 out of every survivors were turned away when they called for help, solely because there wasn't enough space. We're now at 1 out of every 2 are turned away solely because there's not enough space. And in some communities, they aren't saying no, like yours. And you have a program here in Maritzas, it's the highest census in the state. So you either have a turnaway or you're supporting more survivors than, you know, it is possible because they're doing it, but that means more funds are needed. And so we know the ask is hard. We know asking for level funding is hard, but really when we're seeing this capacity crisis grow so exponentially every year, we simply can't turn away now from the problem we know has existed for a very long time. The other thing, and y'all probably have seen, we have a publication produced by one of our other teams honoring Texas victims that really lists in an impactful way all of the women who were murdered at the hands of their intimate partner. We know last year there was a nearly 1/3 increase in the women murdered in our state. And it's hard to not think that that denied and those high capacities has some correlation to the number of women being murdered, because we know that it's 3.6 more times more likely to be killed when you're in the process of leaving. And we need our legislature to understand what we know and y'all know, because you're here today, but we need them to understand in a tough session that doesn't stop. It doesn't stop for survivors. And in fact, it sometimes only gets worse because we're now seeing people use the pandemic to threaten survivors to not leave, to not seek help, to have small windows where they can. And if we say no in that small window, we know from research what might happen. And that's what we need to get across to our legislators, that we get it and we get how hard it is. But if survivors needed us before, they need us even more now. And so that's kind of something we're hoping every community can stand with us and articulate, whether or not it's because you have one of the highest numbers served, or it's because, like Houston, you are turning away almost 80% of all survivors in that community. Either way, that capacity crisis grows, whether or not it grows by one set of policies or another. And we also know that the murders are growing. And it's something we just have to be able to say to them is we get it, we understand, but this is life or death. It's not an option to fund these services. So for us, it's about getting that across, making sure y'all are aware of what we're aware of, which I think you are. We know the work that's being done in San Antonio. We know this is information you guys sit with. And we've had the privilege of reading the report and seeing the work. Even y'all being here today is evidence that San Antonio very much knows. So y'all will have a lot of power, I think, in your voice when it comes to appropriations. And so we highlight it kind of as number one. We also know programs and, you know, Marta, Patricia, y'all can chime in. You've had to change services overnight. So you were strained, your staff were strained, you're trying to find PPE, and now you got to do everything virtually and everything in person. And there's no extra money being given to do that, but programs are doing it because they know it's what's needed. And that's kind of what we need to get folks to understand, that, you know, it might seem like, why would y'all ask for the 63,500,000 and the 13 million? But it's all those things we know deeply and inherently that we have to get across to folks. And so that's really one of our first. And then the last piece, and I think this very much rings true based on all the reports I've seen from y'all, there's definitely keeping those doors open in the capacity crisis, but there's also a huge gap from a survivor who is getting that yes to getting the legal services they need to get to their next home, to getting the home they need to get to their next home, to getting the childcare they need to go to court, to go apply for housing. And so we need extra money to start kind of freeing up the gap that happens, or the bottleneck when survivors come into a program and can't get to what they need next. And family violence programs need the resources to be able to do that. And so our ask is for all of those prongs and to have people understand, like I said, which y'all know so truly in this community. And I know before we go into the others, I'd love if Marta, Patricia, or anyone else wants to offer. I know I'm speaking, but y'all know it much better than me on the ground.
Can somebody tell me the need in Bexar County in terms of some kind of a metric? Maybe Marta, that would be you, or so that we can put some frame around how big the problem is.
Absolutely. Thank you for that question, George. We have had up to 199 victims of domestic violence at the shelter at any one time. Presently, and believe me, I say this with with a lot of thought, we only have 130 people at the shelter today. Agency-wide, last year, we saw unduplicated 12,000 individuals, agency-wide, in the agency, with all of our programs, residential and non-residential. So today, the 130 I am quoting is just at the shelter. Just at the shelter. I provided numbers, as we all did for our last meeting, agency-wide. I don't have those with me right now, but it's a larger number. The non-residential programs, there are more people coming to non-residential programs than there are to the shelter. But anyway, the 130, it already gives you a picture of.
And 12,000 is incredible. It's a huge number.
Yes, it's unduplicated numbers.
Yes.
Unduplicated numbers.
Right.
Yes.
Well, and one of the things that's true for y'all is that the statewide is that for your shelter numbers, you have the highest in the state. And that's because you don't turn away. And that's why we can't use only one metric to really talk about need. And so that's something too, George, that really sits with us, is we can say Houston's at 80% turn away. At the same time, we can say San Antonio had the highest unduplicated shelter because of the policies. And both we have to explain to our legislature that one's not right? One is right for a community and both indicate need.
And
that's typical of San Antonio. I was on the mental health board for many, many years, and we would try very hard not to turn away anyone from mental health services. The end result was exactly that. We'd have to explain why we had such huge numbers.
George, we're also going to be sharing through the commission the data that Marta just mentioned she's shared with us. We're compiling all the data that the different entities have shared with us, and we hope to be able to go over that at our next regular commission meeting.
Okay.
Also, please take into account, you guys, that we're only talking about that which is reported.
Very true.
Okay, so they say that, I think, what, is it only 3 out of 10 incidences get reported?
You know, we're seeing in our state that it's even lower. We estimate only between 10 and 25% of any survivor will ever seek service or get services. So you're very right, Patricia. Yeah. And it may be that one person goes to law enforcement and one person goes to a program, but you're correct to say that even this huge volume that we're trying to get close to is not near where we estimate that there's over 5 million Texans waiting potentially for service.
There you go.
Molly, I just have a couple of questions. What state agency does that funding flow through?
It's to the Health and Human Services Commission, and in particular, the Family Violence Program receives those funds.
Okay. And is it, are there specific program titles that we need to know, or is there a line item in HHS's budget that is specifically family violence intervention?
It's specifically family violence programming, and it's in Article 2. So very good question. Yeah, the specifics are that it's in Article 2 of the budget. Typically, that's our kind of, as you know, Health and Human Services budget. And then we do have a particular line item for family violence program services.
And then are they competitive grants that agencies compete for? Are they formula funded somehow? How does that work?
They're a mix. There's 3 different types of funding in this. There is your shelter centers, your non-residential centers. Those are definitely done via a procurement that is non-competitive, and they just shifted it about a year ago. They went into a new process where you did the procurement and then you had about what it equated to 5 years of renewals, and then you go up for it again. We have always seen it as like a baseline of services. So to not receive it means you had a finding, you had something contractually that didn't meet their standards. They do have another program called the Special Non-Residential Project Grants that is a competitive RFP. It typically opens anywhere between every 2 or 4 years, and we reserve 25% of our Family Violence Prevention and Services Act or FIPSA funds to be used for that in particular. Those change from time to time. The amazing program Patricia runs at one point had those funds, and those are the ones where you do see a fair shift, and it's a mix of people who have other funding or maybe are just starting into funding, or maybe run an agency that doesn't meet all of our core statutory requirements, but are still fabulous programs doing great work in their community.
Great. It would, obviously we're just learning about, I'm just learning about this, and we've got some time before the session, but it would definitely be helpful to understand where those funds have been directed to our community locally. Yeah. So we can make the argument for them.
That's a great idea.
The last question I've got is, you mentioned level funding plus 13.5 million, I think you said, so, or 13 million. I'm not clear on that. What is the plus up for?
Yeah.
If you'll explain.
Yeah, so level funding, and the way we make the distinction is the level funding would only allow us, frankly, to operate at current capacity, current lights, current advocacy, critical, but with the need growing all the time. The other mechanism by which, under especially Article 2 budget, you can ask for more money is what they call an exceptional item request, or EIR. And that is, usually there's anywhere from 30 to 50 strategies coming out of the Health and Human Services Commission of things they've said we need additional money for. Yes, we get it's above and beyond, but it's critical. And so we are pushing them to say, we would like this 13 million in your exceptional item request. And if they don't put it forward, then we're asking the Article 2 subcommittees to put it forward.
Great. That was my question too, was whether this was going to be an exceptional item or not, because there's a lot of competition for those exceptional items. So it really behooves us to organize and lobby really hard for that.
I'm not going to say I heard you volunteer, George, but I've got that in the back of my mind. Yeah. No, you're very right. It's clear you've been working. You're right. That's why we kind of point out the distinction of 63.5. That just keeps us baseline. That keeps us where we are now. But if we're ever going to meet that capacity crisis, that lethality crisis, we estimate 13 million would start us to the road of doing that. Yeah, and feel free. I can also answer questions via chat too. Go ahead, George. Sorry, I saw your line.
No, I have my next meeting starting in the next room. But Andrew is on board here, and I see his name is on there. I will get together with him after the meeting, and then we'll put it on our legislative agenda as well. And then and we'll talk to the teaching hospitals of Texas and to THA as well, which I'm on both. Are
amazing.
All right.
Thank you so much. Yeah, and we're happy to follow up with anything written to send out. So y'all have our email, and anything we can do to support those type of reach outs would be fabulous. Thank you so much.
If I may interject, Molly, at this point, yeah. George, there is additional funding, of course, to supplement everything that emergency crisis shelter is. So there is housing. There may be substance abuse, there may be educational programs, there may be the batterers intervention program. So HHSC is not the only funder for a program. Ideally, should not be the only funding for the program.
Okay, so there are going to be other legislative initiatives outside of the agency. Martha, you just went from one side of my screen to the other, so I'm
when Marta's pointing out on the next thing I'm going to highlight, because Marta psychically has worked with me long enough to just like open a door for me to talk about our broader intervention and prevention programs, which is one of our other funding parties. Because Marta's right that, Health and Human Service Commission lights on, but that doesn't mean we don't need housing. We don't need more legal. We don't need mental health. And one of the things we hear survivors say they want the most is they wish their partner would change. They want something different for themselves and their families. And so as we all look at our criminal justice system, one of the ways in which we can invest in what survivors are asking us to do is to support BIPs. In our state, it's a very small amount of money. and it's done via a rider. You don't see it when you scan a budget. You see kind of the totality of the Texas Department of Criminal Justice budget. And there's a little line that says you will direct funds to the Battery Intervention and Prevention Program. So roughly about $3.5 million is our BIP request. We stand with that because, again, Martha's and I, we want program services, but we also want to make sure we're investing in change work, thinking about how to hold offenders accountable for behavior, right? And BIP is really our main way in Texas, outside of any criminal justice side intervention, to do that with survivors. And so that stands as one of our financial legislative priorities as well. And then the last piece, just so I make sure.
All right, real quick, would you just say the number again? I missed that.
Yes, it's a rider of 3.5 million. And I'll put these in the chat, y'all, when I'm done, so you don't have to, I can put a number stream in the chat too. I know it's hard to have people roll out numbers. And then our last piece is, we know there are times when a survivor, a system has already seen the risk radiated, right? They've already seen the lethality measures. Maybe there's a lap protocol, maybe there's another indicator. And so we have had the long kind of maybe 5-6 year partnership around lethality reduction with our Office of Attorney General for our domestic violence high risk teams, or DVHRT. And Alexandra and her team do that work, and we have a coordinator on staff. And this is kind of a wraparound approach for a survivor whose offender has had markers to show a higher risk for lethality. For that, it's the same thing where it's a rider, it's a direction to the agency for the money, and we're looking for $600,000. We're really only looking for level funding. The only additional funds we're asking for this session are when it comes to family violence program services. And I can again put those numbers in the chat just so y'all have our kind of full request down there. But we're kind of always looking at services to survivors as a wraparound to the services provided, the lethality radiated, and not primary prevention, but tertiary prevention in the form of our BIP programs. And with that, I know I've taken too much of your time talking about money and could take a whole hour talking about money. But I also know Krista Delgado could really talk to you about one of our other priorities. So I'm going to turn it over to her, and I'll answer questions in the chat if y'all have any.
All right, thank you so much, Molly. And I'm going to talk about one of our priorities that is, I have a different term for it every time, like pop culture term. It's a remix from last session. We had a lovely bill last session. It was Senate Bill 1804, authored by Senator Kolkhorst out of Brenham, and it would require that information about conditions of bond for family violence offenders. So at the time in which somebody's been arrested for family violence assault and they're being magistrated and being released out on bond, there's a whole section within the Code of Criminal Procedure that's specific to the types of conditions of bond that can be applied to those folks for victim safety and for that person's accountability. Unfortunately, a main problem with that is, even though magistrates are doing the good work of thinking about what could be some tailored safety provisions we can insert as conditions of bond before a release, and they put that in there, there's two huge gaps. First, the victim is not notified of those conditions. So you could have a victim that all of these conditions of bond were entered for their safety, and they could be completely unaware. So they don't even know that the court has taken this step, or that this is something that the other person could be in violation of. The second piece is these conditions of bond currently have no place to be entered into the Texas Crime Information Center, the TCIC, which is the information database, as you all probably know, that law enforcement really utilizes to know when someone is in violation. So while violations of protective orders, violations of conditions of bond, violations of magistrate's orders of emergency protection, all are included in the penal code with the same type of penalty for violating, one of those conditions of bond are not actually findable within the TCIC for law enforcement right now. So the victim is not aware that they exist, and then law enforcement can't even know to make an arrest when they see a violation of these conditions. Last session, we had a bill, Senate Bill 1804. It passed unanimously through both chambers. It unfortunately had some, extreme sausage applied to it, whereas our very own sponsor on the House side actually added a nuclear waste amendment that, and this was very late in session, that then the governor felt that he had to veto the bill in its entirety because the amendment was so clearly non-germane to the issue. And so it went down. And so even though the sense of the legislature was that this was a law that needed to be passed, it unfortunately met its demise. So we are looking to go back to the legislature next session and refile the same or very similar legislation. We also know that this really helps us to be a part of the conversation around bond and around what happens at arraignment, and why it's so important to really consider safety and the very specific safety needs of victims of domestic violence. So it is helpful that we already have this section in the code and that we're moving this priority again, because it really is something that allows us to insert ourselves into those conversations where it's extremely important that survivor advocates are in those rooms talking about safety and talking about what a really tailored and responsive release will look like for survivor safety. So I'll pause there because I know we've got a lot to get through, and let Alexandra talk about our other Más o Menos remix that we have going on.
Thanks, Krista. Yeah, so the next topic that we wanted to address, and we're hoping to address during this legislative session, relates to specifically domestic violence homicide, and more specifically, it's addressing a means of homicide that is generally the highest risk factor when it comes to lethality, and that's firearms. And so first, I wanted to share why this is of such high importance and why it really is typically elevated with our public policy committee. And Molly had already mentioned the Honoring Texas Victims report that we publish every year. And so beyond honoring and recognizing the women who've been killed by their male intimate partner in Texas, TCV also does an analysis on the homicide trends throughout the state. And so from the research that was identified through that report over the last decade, we found that 63% of all women who are killed by a male intimate partner are killed by a firearm. And so just as a reference point, the national average is 53%, and in Texas it's 63%. So although it's really clear this is a serious issue nationally, it's really even more dire in Texas. So while our work also focuses specifically on the safety and well-being of victims of family violence, it's also important to note that this is a topic that's important to the community safety at large as well. Just generally, more than half of all mass shootings that occur across the country, and that is identified or defined as 4 or more murders at one time, the perpetrator has also shot a current or former intimate partner or a family member. And so there's a really big connection between mass violence as well as domestic violence. And so one of the bill considerations that we are going to be hoping to find a way to address this topic would be, as Krista had mentioned, remix, a refile of the bill that was filed last session by Representative Moody out of El Paso, and that's HB 3191. So just as some background on this bill and why it's important, so family violence offenders have been prohibited from possessing or accessing firearms under state law, so under Texas law, for almost 2 decades. But right now, most Texas jurisdictions lack any protocol that will provide a process for those firearms to be relinquished. And that really just means that there's no ability for a safe surrender of firearms for those who are not able to or not supposed to and have been prohibited from possessing or accessing firearms and ammunition. So this particular bill would require that all Texas counties convene a multidisciplinary collaborative to develop and implement a family violence firearm protocol that's consistent with state law and that would also be in accordance with best practices and would address the relinquishment issue, the storage issue, the inventory issues that we know are a part of the process of what a safe and well thought out surrender protocol would look like. So the reason that this bill was crafted in this way that would require each county to bring together a group of collaborative individuals, and it does prescribe specific individuals that would be important to that conversation, is because we know that Texas is a very diverse state and each county really requires very different protocols and processes. We know that, for example, Bexar County is likely to require a process that's very different than Wilbarger County. Travis County is going to require a process that's very different than Dallas County. And so the goal was to really be able to have these communities start this conversation and think through what that would look like and how it would be most effective in their own community. A point that I want to make is that the bill originally, HB 3191 specifically, did not require an implementation of this protocol. It really required this conversation to start and for that protocol to be outlined and then submitted so that there at least was that starting off point of thinking through what that protocol may look like moving forward, as well as what needs there might be for that community to effectively put that protocol into place. So alternatively, another consideration we have to address the topic specifically of homicide reduction, as well as firearms and the intersection with domestic violence, would be to mandate a task force on domestic violence homicide reduction to conduct an analysis of the intersection between firearms and domestic violence, as well as other means of homicide. So this bill would define membership and duties of the task force, as well as require that task force to develop related policy recommendations, best practices, and publish a resulting report the following year with some of those recommendations. And so those are two of the avenues that we are considering to address this particular topic on our agenda moving forward. But,
just a quick question. Moody's bill seems like such a no-brainer. In fact, it's a soft approach to allow each county to go create one as opposed to mandate it at the state level. So what happened with it? Why didn't it get anywhere last session?
Well, to be honest, I think that anytime you're talking about firearms in Texas, it's an uphill battle. And we know that, and we knew that going in, but it was such a high prioritized piece from the folks that we talk to across the state, from family violence programs who are serving survivors, from prosecutors, from judges, and from other stakeholders that we work with within our public policy committee. And it was one of those pieces that we knew we had to move forward with, regardless of, you know, the stigma that comes along with firearms in Texas. So I would agree with you. I think this is a really easy one because there isn't that, you know, that specific statewide mandate. And it's really just requiring or wanting the counties to start that conversation so that they can see what issues are in place and how they can address them in a way that will not only provide additional safety to survivors, but also to the community. Yeah, we definitely, I mean, I agree with you.
Yeah, I'm glad you got what I meant. I didn't mean soft in a negative way. I mean, that's it's almost an easy vote for a legislator when you simply direct them to go create a solution for it. I lost my train of thought. I'm sure I'll remember the question again in a second.
Not a problem. Yeah, and if anybody has any questions right now.
Sorry.
Oh, yeah, go ahead.
I remember. So did I get this correctly that state law already prevents someone with a protective order filed against them from possessing it? This is just the process for surrendering it. It's not even the...
That is correct, yes. Okay. Currently, an offender, so someone who has a felony, a felony conviction, or a misdemeanor conviction that involves family violence are prohibited from possessing or accessing a firearm. And those who have or the subject of a protective order are also prohibited from possessing a firearm or purchasing a firearm. And this is Texas law, while it's also within federal law that does not allow and prohibits those individuals with similar types of convictions and protective orders from possessing a firearm. We currently have Texas law that also prohibits that possession. And so this would not be changing the law. This would not be expanding the prohibited possessors. This would really just be identifying the best way for a county to go about enforcing current Texas state law.
Great, thank you.
Of course.
Alexandra.
Yes.
Also, we have some good models in other parts of the country where this work is being done. You know, in Louisiana, in Seattle, even in Dallas, I believe, right?
Yes.
Where they're being very successful in terms of getting, you know, guns taken away from perpetrators. And you know, we've got definitely some clear models to look at where they're being very successful and they're preventing homicides big time. And that's the stuff we need to be looking at and emulating.
And Patricia, I wanted to let you know that we are doing that in our Judiciary Committee. We're working on a firearm transfer process. We've made a lot of progress, and we're utilizing those best practices from those other communities. So we hope to have something to roll out by the end of October here locally.
Excellent.
Yeah, and yeah, you're absolutely right. I'm sorry, go ahead, Judge.
Well, and I was going to ask, what would be helpful is if, and I don't know where TCFV is on this, if there was actually a statute, rather than just saying, you know, pushing for the legislative agenda, hey, we're going to just have our counties do their own thing, actually having a statute that would effectuate the transfer. Is that, I mean, I guess, is that the same thing that what you're doing?
And so are you referencing then, like specifying how that transfer would look in statute?
Or even just saying, you know, with the protective orders that are filed, you know, there's going to be whatever document, a motion to transfer firearms if the applicant's attorney at the time of filing knows that the respondent is in possession of firearms. Or, you know, having within the protective order statutes, a motion to return upon the expiration of the protective order. Like having something codified would help create the process for transferring a lot more straightforward. I don't know if that's something TCFV has thought through or what exactly is encompassed with your legislative agenda to give the counties the flexibility to effectuate the transfer. I don't know. I guess, could you go into a little bit more about what exactly is encompassed with that part of the agenda?
Sure. Well, I think I understand what you're saying, and correct me if I'm wrong, in that there would be some sort of specific codified piece that would allow for a judge or an attorney for a survivor to point to a document that would be utilized in order to have that firearm surrendered, rather than allowing for the county to make that determination within the county. And I think that the main, I'm sorry, go ahead then.
Well, not even the document itself, just the, like, you know, in the protective order statute, it's like who may file the protective order, and it codifies who may file the protective order.
Sure.
Why not have a section, you know, what you could file to effectuate the transfer or to begin the transfer process, or something that you don't even have to have the template outlined, because I agree that there's going to be a lot of distinction between the counties with the actual documentation. But even within the code, where are we pointing to say this is where the process starts, this is where the process ends?
Can I jump in here too? Have y'all thought
Yes.
about maybe bracketing this somehow to like the big 5 counties or the metro 6 counties, because it's going to get killed by the smaller counties. You hit, you know, on the firearms, so don't take my guns away. Or, you know, the rural counties aren't going to like that. and then the smaller counties just aren't going to have the capacity to do this. So maybe if we start with a bracket for the larger counties and start there. So that'd be something that I'd throw out to consider as well.
Yeah, no, and I appreciate that insight. I think there had been some discussion as it related to, you know, capping it at a certain metro area. The problem that we found with that is that counties tend to overlap in judicial districts. And so then you would have a protocol in place for a particular county where a court is overseeing both of those counties and doesn't have a protocol in place for one versus does have a protocol in place for another. And so I think there's just some layers of difficulty in being able to approach it in that way. And I do think there are some smaller counties that are interested in being able to have some requirement or mandate to create that protocol. And so that was our hesitation. Although I definitely understand, you know, what you're pointing to.
Would y'all be amenable to bracketing it just to Bexar County for us to maybe start the process and see if it works? And then, because if we can start it and it's successful here, then maybe some of the other counties would come on.
Sure, and I do think that it sounds like Judge Diaz has mentioned that y'all are moving forward with a firearm transfer process. And so there are other counties right now that are, you know, creating a protocol and moving forward with it. And I think those are the ones that we do point to when we try to discuss with legislators that this is working. There are areas that have implemented a protocol. But I would love to, you know, to chat with y'all, especially if you have ideas offline. I want to make sure that you have our contact information. I'm sure Judge Diaz or Noah are able to provide that. But I know that we only have 4 minutes left, so I wanted to maybe just very briefly touch on a couple of the topic areas that we are not going to be moving forward with on our agenda, but rose and elevated within our Public Policy Committee conversation, because I know that one of the pieces that we wanted to be able to provide to you is some other ideas that may be something that Bexar County would be interested in taking on.
And I am going to keep the recording going, and I can stay on as long as we need. If anyone needs to leave at 5, I understand. We'll share the recording after we're done. So if you got to go, you can catch the end. Afterwards, if you have any additional questions that haven't been addressed, feel free to put them in the chat, and we'll make sure that those get answered via email at least. So thank you, Alexandra. You may continue.
Yeah, of course. And I'll try to be as quick as possible because we do have 3 additional ideas that are not going to be something that we're moving forward, but have been something that have been elevated by our Public Policy Committee members, as well as just stakeholders across the state. So the first one is relating to judicial training. And so that would be an amendment of the government code to require that judges receive a minimum number of family violence training hours and to define what those curriculum standards look like. So I know that we have some judges in the room, so I'm sure y'all are aware of those training requirements, but for those who aren't, currently judges are not required to have specifically family violence training. And I say that, and I'll provide a little bit more information about that, because within a judge's first term or judicial officer's first 4 years of service, they have to complete 12 hours of training. At least 4 of those hours have to be dedicated to issues relating to trafficking as well as child abuse and neglect. And then 6 hours have to be dedicated to a couple other areas of training. One of those being specifically community resources, one of them being gender bias in the judicial process, and the other one being dynamics or effects of being a victim of family violence, sexual assault, trafficking, or child abuse. And so because family violence dynamics are lumped into that larger set and included within sexual assault, trafficking, and child abuse, it is possible that judges may not receive any family violence training at all and still meet those training requirements, because they could be receiving training within those 6 hours for sexual assault, for the gender bias and judicial process, for community resources, for child abuse, for trafficking. And so we know that family violence concerns can arise during many different types of legal proceedings, and that includes criminal cases, protective order hearings, custody issues, divorces, and many other civil proceedings. And so we know that it's really of the utmost importance that judges have a basic understanding of the dynamics of family violence to really just ensure that they're supportive of the survivors that they're encountering within the judicial system. So I think that this bill, I wanted to bring this bill to y'all because I think it would have a very large impact for survivors, and it's a relatively straightforward bill. It would really require a relatively small shift within the government code, and it really would provide a tremendous benefit to survivors of family violence across the state. And I, of course, if you have any questions, please feel free to shoot them in the chat or provide them at a later time, and I'm happy to talk through it. But I wanted to turn it over to Molly to talk about another option.
Yeah, as Alex said, we wanted to tell you about our priorities, but some other that we know are really well vetted that could be an option for a community to take on. And much like the one Alex described, we've been alerted that there's what looks like a small issue in crime victims compensation that results in a large issue for survivors. So I know y'all are probably familiar with crime victims compensation and use that frequently in your community. Right now, if you're looking to get psychiatric care or counseling, they've used a reference to a definition that says you have to live in the household and be related by blood or marriage. When you originally look at it, you don't pick up on what that means is dating violence is not included. Probably roommates if you're in a college community, right? So you've got this huge gap that's been created for one of our most critical crime victims compensation resources. And then that's already enough to think that we could have been dating for 5 years, living together for 5 years, and I need this help, but because we're not related by blood or marriage, I'm not eligible. The other piece that's been raised to us, and this is probably really familiar, is that rent and relocation assistance rests all the time as one of our top crime victims compensation needs for the domestic violence community. In any given year, we're sometimes up to or over 50% of all rent and relocation. And a similar definitional issue exists that victims of dating violence technically are not eligible for rent or relocation. So again, same thing. You could have been with someone for any measure of time, but they pulled in only one part of our family violence definition from the family code and not all of the pieces. And so I think our crime victims compensation experts do their best to say, well, was there stalking? Is there a way we can get it in? But it's been shown to us that this definition challenge means many victims, particularly of dating violence, do not have the full weight and breadth of crime victims compensation available to them. So much like the judicial training, it's probably not a super hard road forward, but could impact many Texans to easily access counseling, rent, relocation. And I think the department is, they're aware of it and they do their best to work around it because we have a really great crime victims compensation team. But it's still there. And it's still there for any victim of dating violence, particularly. So we raised that one up too for y'all because we know how involved y'all have been around this. We know that crime victims compensation, when we see numbers coming out of San Antonio, they're usually pretty high. So it's clearly a measure y'all are using in your area. And with that, Chris has got one more good idea for you that I will let her offer.
All right. And this is just such an incredible group. I've already learned so much and gotten so many new ideas that I hadn't thought of before. So thank you all so much for convening this and for your involvement and participation today. So the other idea I was going to discuss is around just doing some type of an assessment at the top of a case, either when a suit for a divorce is filed or when a suit affecting a parent-child relationship is filed, to see if there is a need for one party to shift funding over to the other party for the purposes of securing representation. So one of the huge issues that we knew about, but also really came home from the family law attorneys that serve on our public policy committee, is that oftentimes when if they're able to get involved in a case, it's oftentimes too late. And Marta can tell you about this, that she actually is one of the very few programs in the state of Texas that has an attorney or two on staff, that some clients, gosh, that's so amazing, that clients can actually utilize for these civil cases. That That is a very rare thing. When we said that you all have exceptional services in San Antonio, for real, that's sort of a Cadillac of domestic violence services to have for attorneys on staff. The income threshold for legal aid services is 125% of poverty. So that's sort of your other avenue for civil legal services. And so many folks are above that, which we know is still not someone that has enough money to put a $10,000 retainer down and then pay several $1,000s every month for their divorce or custody case. But what we know is that even if the abuser has resources and they go into that initial filing of a divorce, oftentimes they'll siphon all those resources off or block the other parent or spouse's ability to use any of those resources to secure their own representation. And so we're looking for some place in the code, be it in the protective order statute and in what judges need to remind litigants of when a divorce suit is filed, that really helps to assess whether or not each party has the assets needed to gain counsel. And if one party has a lot, then they might be told to shift assets over to the other, particularly in a marital suit, to the other spouse, so that spouse can actually secure counsel as well. And this would go far to addressing the issue that, and I'm not sure how the judges in San Antonio are, but I know a lot of judges across the state are not, they don't see pro se litigants in a very favorable sight. And certainly pro se litigants in a divorce or a custody suit are going to fare very, very poorly, as are anyone that is sort of almost more likely to fall into what I call sort of predatory lawyering, where they say, yeah, I'll take your case. But you just have to, if you can come up with $3,000 by Friday, I can take your case. And then that lawyer doesn't, because it's such a complicated case, that lawyer doesn't really work on it, and the survivor is not able to continue to give them any money. So it's really to address this idea of access to counsel through the assets that potentially could come from the abusive partner, abusive spouse, and to sort of even out the playing fields. Because what we're seeing, and again, this is a generalization across the state, it might be a very different picture in San Antonio, but for instance, things like child custody, when that's involved in a divorce, the outcomes, particularly for a survivor parent, if they didn't have money to secure the type of representation that they really needed, are oftentimes very poor. And that means it's not just that this parent didn't get exactly what they wanted. It also means that potentially those children are less safe and that parent less safe. And so it's really addressing access to counsel in these civil matters that really hinge on family safety. And when any type of breakdown, like Molly mentioned, when leaving is the most dangerous time, when folks are involved in these types of litigation, so either a divorce and or a custody suit, that also increases the prevalence and exacerbates the potentiality for violence. So that's the other piece that we were exploring and looking at, and there's many attorneys that are really willing to think that through a little bit more about where it could go in the code. I know that Jennifer Rainey Rodriguez, or is it Julia Rainey Rodriguez, that's on the commission. She's also part of Texas, she's colleagues with many of the people on our public policy committee. She used to serve on our public policy committee. I think she would be a brilliant person to bring into this conversation, but really addressing that access to counsel so families can have better outcomes in those civil matters.
So I don't know if this is something that we could do because of the Judiciary Committee. Well, maybe, I know we've got our own public policy committee. It sounds like what you're wanting perhaps would be some tweaking or even an addition in the family code for interim support. And that family violence, just like it's a component in the conservatorship section, that family violence would be a component in assessing interim support. And if you look at the family code, if you look at that section talking about spousal support post-divorce, there is no codification of the interim support. And a lot of judges apply what's codified for post-divorce maintenance and do it interim, whether they're assessing the 20% or 5,000 or, but there is nothing even post divorce maintenance except for conviction of family violence taking into account. So maybe moving away from the conviction on the post-divorce provisions and putting an interim support provision that mirrors the conservatorship, where it's just a finding of family violence that would trigger a burden or increase the likelihood of interim support, and you could capture attorney's fees that way. I would be cautious of limiting that kind of thought to just interim attorney's fees, because you've got housing issues, you may have some credential issues, some education issues that will come into play and make a better case for increasing the interim support. And that's assuming that there's resources there, right? Like when you talk about self-represented litigants, you're talking about a community estate that's already going to be upside down, right? And then I don't know how you would get to that kind of funding or that kind of reallocation of resources when you're just dealing with SAPSers.
Right.
There is no obligation. There's no community estate to divide or to divvy up. But those are my thoughts, just thinking off the top of my head about how legislatively you would try to capture that sentiment.
That's fabulous. And you're going really where some of the legal minds were going in this as well, like looking at Chapter 6, and where the judges have to look at if there's evidence or they find out about family violence, they have to at least look and see if there's a protective order, or advise folks that protective orders are available potentially to them. But there's nothing that really looks at, like, do you need support in this interim? And so often the temporary orders that most of the survivors receive are boilerplates, like they're standing orders in divorce cases. And so they don't necessarily address this tailored sort of interim support if there is the ability on one side to actually provide that. So I think that's a great idea. And I also really, I haven't gone back to the post-divorce spousal support section for a long time, because it's just one of those things that I talk to attorneys sometimes in Texas, and they're like, well, we don't actually have alimony in Texas because it's so limited where spousal maintenance is available in the code, even though a judge can certainly order it. So I really like sort of opening that up beyond the conviction, because it is such a high bar to really trigger the actual spousal maintenance.
Thank you, Judge Alvarez, for that input. I was trying to figure out what that would look like, and you made it really clear for me. And I am so impressed at the presentation that you guys provided us. And I really think that the items you identified out of the 100 or so that y'all got initially, that you kind of narrowed down to the recommendations you've selected, the ones you identified for our community really do make a lot of sense for us to consider, and piggyback off of a lot of the efforts we're currently working on. So I just wanted to thank you all from the bottom of my heart for taking the time to prepare this for us, for meeting with us beforehand, meeting with us today. It's really critical to the work of the commission. And our next step is to share this recording with those members that couldn't join us. And we'll be asking each of the committee chairs to prioritize those recommendations for their committees, and to provide any additional recommendations that have been identified through the work that they've all been doing. And then thanks to Jeff Coyle on this call, who's our policy work group chair. I want to, before we wrap this up, because I know it's 5:13, I want to pass it back over to Jeff and see if you have any questions that would help with your work with the commission going forward, or anything that we need to do.
No questions. I'll just share that I believe both Melissa and I are putting together our respective legislative agendas for the city and the county. Domestic violence prevention has been a priority, so I don't suspect we'll have any trouble including expressions of support for these items. But before we do that, I think to Judge Diaz's point, we'll want to discuss it with the commission, get everybody's buy-in, and hopefully get everybody's help in rowing the boat next session. So we bottom line is we didn't want to try to create the wheel here. We wanted to be able to latch on to somebody who's been doing this work at the Capitol for some time and knows these issues and can give us some concrete things to rally behind. And you've done that today. So thanks.
Thank you, Jeff. And so what I'd like to do is I know y'all have done so much already, but I wanted to see if it's possible for us to get, if you already have these recommendations that you shared with us today, if you maybe have a summary of the ones that you want us to review that we can share. I took notes, I just don't want to butcher it. So if it's possible for y'all to follow up maybe with bullet points of the ones that you're asking us to consider in the language that you want us to consider it, that would be helpful for me to share that with our commission members and make sure that I don't get it wrong. Is that something y'all are able to share after the meeting today?
Yeah, we don't have like an official document yet, so certainly we can send an email with follow-up. And we are submitting this week our testimony on appropriations that will be of public record, and we're happy to give you that as a long form. It's 5 pages, so you'll have more appropriations detail than you may have wanted. But we can work to draft this at least into an email with high-level bullet points that you'll have. And then probably, a month or so from now, we'll start to have print materials with the appropriations, the TCIC, and the homicide reduction via protocols that Alex outlined.
Wonderful.
And I did put our emails in there to all 3 of us. Really, if you don't remember who presented what, you're welcome to get with any of us. And of course, Samantha and Patricia are always conduits to us as well. We get to work with them all the time too. So definitely, they may be better fits for questions at times too. So any or all of us at any point.
Thank you.
Well, also be thinking about some of the ways that we can support what's happening at the Capitol come January.
We're going to have a purple postcard soon. So just in about a week, y'all are going to be hearing from me, and I'll share it with this whole group too. It's one of our biggest appropriations campaigns to raise voice. So I will be taking y'all up on that.
Thank you so much. Well, I appreciate everyone. I know the meeting has gone a bit over, so I want to be respectful of everyone's time and just thank you all once again. If you think of any questions afterwards, please feel free to email them to us, and we will make sure that we get them to the wonderful folks at the Texas Council. And I know I've said it already 3 or 4 times, but I'm very, very grateful for each and every one of you, in particular, the folks at the Texas Council that took the time to come out here today. So I'm going to wrap up this recording. Thank you all once again. I'll be circulating it via email shortly, and we will see all of you soon. Have a good rest of your day.
Thanks, everybody.
Bye. Thank you, Molly, Krista, Alex.
Bye, y'all.
It's so good to see y'all. Thank you for coordinating this, Judge Diaz. This was fabulous.
Thank you.